welcome to our final session of the 19th Annual Fall Ethics Symposium. The theme this year is on hope and change. Our moderator of this final session is Melissa McPheeters.
Thank you, Dr. Swan. Good afternoon. My name is Melissa McPheeters, and like the other session chairs before me at today's event, I am a student in the Cosumnes River College Honors Program. After this introduction, this session will consist of our main speaker's presentation. After the introduction, this session will consist of our main speaker's presentation, which will be about 40 minutes long. After the presentation, we will hear briefly from our formal respondents, to whom our speaker will have the opportunity to reply. Finally, we'll open up the floor to you, our audience, for questions. Please note that this event is being filmed for broadcast by the Sacramento Educational Cable Consortium. Our speaker for this session is Dr. Harry Blain. Dr. Blain is an assistant professor of political science here at Sacramento State, specializing in constitutional law, law and society, and civil liberties. In addition to his academic research, Dr. Blain has written for The Guardian, Open Democracy, Foreign Policy in Focus, Counterpunch, and other popular media outlets. He will be speaking to us today about politics and the Supreme Court, the search for the informed pessimism. Please join me in welcoming Professor Blain.
Thank you very much for the kind introduction, and thank you everybody for coming. I appreciate the invitation as well. Really looking forward to having this conversation with all of you. Might just say one thing at the outset before I get into the substance of my remarks. I was here this morning for at least one of the panels. It was very good, constructive discussion in the Q&A. I think the students, as always, ask great questions. Maybe sometimes students feel when they're asking questions to faculty that they want to be polite and deferential, and I really want to just emphasize at the outset, both to the students and also to the audience, that at the end, I really want you to ask the most critical questions that you can possibly think of. I won't say hostile questions, but the most critical questions you can think of, I would really welcome, because I think having my statements and my arguments challenged is obviously a good way for me to refine them, but I think it's also the best way for all of us to learn something throughout the course of the presentation today. So I would say that the main theme or the backdrop for my presentation or my argument is this relatively clear trend with some variations over time, which I will summarize as the Supreme Court of the United States is not particularly popular right now. Actually, historically speaking, compared to the other branches of government, especially the United States Congress, which for the past 30 or 40 years has had absolutely miserable approval ratings, the Supreme Court actually has done rather well and is still, in comparative terms, doing rather well. But it has been suffering a lot, especially over the last 2 years, I would say especially since the Dobbs v. Jackson Women's Health Organization opinion that overturned Roe v. Wade. Definitely drops in popularity. If you dig into the polling data a little bit more, I think you can see, again, it probably wouldn't be a surprise to most of you. There aren't too many respondents who think that the Supreme Court is too conservative. There are a few who think it's just about down the middle, and there's a large number, a growing number, who think that the Supreme Court is way too conservative. Okay? So these are the dynamics that we are seeing. In other words, I think that a lot of the pessimism about the Supreme Court, growing pessimism about the Supreme Court, is definitely coming from people who would describe themselves in opinion polls or in public as either liberal or progressive. I think then, if we take a look at a little bit of anecdotal evidence as well, another thing that definitely provoked me to give this speech and this presentation was a piece in the New York Times from February of this year that was written by Jesse Wegman, a member of the editorial board, that involved multiple interviews with constitutional law professors across the country. And again, the general picture was negative. In fact, I would say the general picture was beyond negative. The general picture was dire from the vast majority. It is true that they would also have mostly identified themselves as liberal or progressive. But there were also some comments, not very many, there were some comments from self-identified conservatives that were also critical, but probably not quite as critical as the headline comments that I could essentially distill as constitutional law professors wondering how they could even teach this subject matter anymore, because it's premised on the idea that the Supreme Court is at least a somewhat legitimate institution, and they can actually no longer bring themselves to accept that, in their words, illusion. As I mentioned before, I think a huge part of the backdrop for this growing pessimism is to do with recent decisions of the Supreme Court. There have been quite several on a wide variety of controversial topics, including affirmative action, gun control, the various legal troubles of former President and quite possibly future President Donald Trump. Probably the one that stands above the most in terms of its impact on the polling data and in terms of how people respond to it more generally in either academic settings or in opinion polls, is that Dobbs v. Jackson Women's Health Organization decision that overturned the nearly 50-year-old precedent of Roe v. Wade. And I think the bulk of my focus today is actually going to be on that decision because of its significance within this broader narrative of pessimism. I think there are some other factors too that I will be discussing to varying degrees throughout the course of the presentation, but they're a little bit more in the background. And they really concern, let's say, the manner in which the Supreme Court of the United States has come to be primarily conservative. And I think that one side of that is the fiasco back in 2016, the beginning of the year, the death of Justice Antonin Scalia, and then the effort thereafter by President Barack Obama to exercise his constitutional obligation, I would say, to replace Justice Scalia with would-be Justice Merrick Garland. And the Republicans in Congress responded to this by refusing to even hold confirmation hearings. And, by the way, perhaps more substantively, more importantly, obstructed judicial appointments all the way down the levels of the federal judiciary at the appeals courts and the district courts as well, thus opening the door for President Donald Trump in 2017 to essentially pack the judiciary with people who had been recommended to him by the conservative Federalist Society. Such that in our federal courts today, forget about the Supreme Court, which has a 6-3 conservative majority, probably a similar ratio exists all the way down to the district courts, the trial courts where federal cases are first heard, and up to the appeals courts, roughly 2/3 majority for justices who would widely be considered to be conservative. So I think that, in other words, the pessimistic view of the Supreme Court today is that it is something of a conservative wrecking ball. That's the expression I would like to use. That it is a politicized institution, and that it's also an institution that is overstepping its proper boundaries. My argument is that, in general terms, pessimism surrounding the Supreme Court of the United States is actually a darn good thing and has deep and storied traditions in the history of this country. And I'll start by outlining some of those deep and storied traditions. However, I also will be making the argument that the current pessimism around the Supreme Court is based on an exaggerated view of what the court can actually do, its actual impact on society, and also an exaggerated view of its politicization or polarization or its ideological divide. So pretty simple and straightforward. Let me start with a bit of this pessimism about the Supreme Court historically and more generally, and why I think in general this is not such a bad thing, perhaps even a commendable thing. Probably for most of us who are talking about the Supreme Court today, when we hear arguments about the Supreme Court having too much power, or the Supreme Court making decisions it ought not to make, engaging in improper judicial activism, These arguments very often come from the right, very often have come from the right in recent times, particularly since the foundation of the Federalist Society in 1982, which was founded essentially with this concern about so-called judicial activism as its number one motivating factor. But this is really a function of fairly recent history in the country. I think that skepticism about the Supreme Court, criticism of the Supreme Court, pessimism surrounding the Supreme Court has very deep roots. I think that some of these roots took particularly significant form in the aftermath of the Dred Scott decision in 1857, which essentially prohibited the federal government from regulating the expansion of slavery into federal territories. This led to a very fierce reaction within the Republican Party, which at the time, I would say, included a very large number of progressive and small d democratic forces, up to and including President Abraham Lincoln, who in his first inaugural address provided a very sharp critique of the Supreme Court and the idea of the Supreme Court being the final arbiter of constitutional disputes, saying that if the Supreme Court is to be the final arbiter of all of the vital questions affecting the whole people, then the people will have ceased to be their own rulers. This is a very small d democratic argument about why we should not have an institution which, after all, is not elected, is essentially 9 monarchs because they serve for life, weighing in and deciding on some of the most important issues that the country faces. I think in terms of a basic democratic ideal, that is a commendable and defensible position. And it's one that progressive and democratic forces within the United States, within the Republican Party, maintained throughout the Civil War and Reconstruction when they also had further confrontations with the Supreme Court. I might argue, however, that this, let's say, progressive pessimism reached something of a crescendo in the 1930s. And it reached something of a crescendo in the 1930s because in the first 2.5, 3 decades of the 20th century, the Supreme Court of the United States was fairly active, in many cases very active, in striking down various forms of legislation at both the state and the federal level that were in various ways trying to make industrial capitalism more humane. Minimum wage laws, maximum hours laws, health and safety laws and regulations at both the federal and the state level. When we talk about this era or this movement as the New Deal, we tend to think of it primarily as being the federal level programs, but actually the New Deal is actually much more in terms of on-the-ground impact significant at the state level. That's where a lot of the legislation that actually changed our lives was passed. And the Supreme Court did obstruct a lot of it. And because of this obstruction, progressives in Congress, and of course in the White House in the form of Franklin Delano Roosevelt, became very skeptical of the Supreme Court. But not only did they become skeptical of the Supreme Court, they became skeptical of the whole idea of constitutional rights. The whole idea that we should have this unelected institution protecting people's individual rights against the efforts of democratic majorities to pass legislation that everybody needs. In particular, they were concerned with this concept of liberty of contract that the Supreme Court used to strike down social and economic legislation during this period. The logic was a bit twisted, and justices, or future justices, Felix Frankfurter down here, and Robert Jackson, and also William O. Douglas, and then someone who's not on the screen, Justice Harlan Fiske Stone, all argued that this concept of liberty of contract was ridiculous because it basically said that a maximum hours law in the state of New York for the bake shop workers who were working in pretty intolerable conditions actually violated their rights to work more than 60 hours a week if they so pleased. Maybe it would be appropriate for them, if they so wished, to work 100 hours a week. But of course, the progressives on the court and in society said that this kind of logic is absurd. It doesn't have much of a basis in the history of the Constitution, certainly not in the text of the Constitution. And it's also obviously a very warped perception of freedom, probably so warped that it's not really necessary for me to explain it in a lot of depth for people today. But obviously, the choice between working 70 hours a week or starving is not exactly a free choice. So let's say the progressive pessimist position, which you can probably tell by the tone in which I'm presenting it, is one with which I have a decent amount of sympathy, is that the Supreme Court should generally not be intervening very often in the democratic process, should only be doing so for very good reasons. And those very good reasons really should be there's a solid constitutional basis for doing so. Okay, and we might need to elaborate a little bit more on what that means. It's not necessarily just the text of the Constitution, but at least something in constitutional or legal or even social traditions that have developed over time. But it's very important that we view the court skeptically, that we view the court pessimistically, in part because of this fact that at bottom it is a fundamentally undemocratic institution, although it's obviously a part of what is overall, in theory at least, a democratic constitutional structure. Now, I think there's one difference already between this progressive pessimism of the past and the pessimism of more recent times, the pessimism of today, let's say. And we can see this in criticism of the court stemming from its decision to overturn the Roe v. Wade decision. It's important for me to give you a bit of an explanation for this because I don't think that everybody will know this subject matter or this history particularly well. But when the Supreme Court overturned Roe v. Wade in the Dobbs v. Jackson Women's Health Organization opinion from 2022, what it was literally doing, we might have a different discussion about what it meant in practice, but what it was literally doing was actually retreating from a prior invasion into the democratic process. What do I mean by this? What I mean by this is that when Roe v. Wade was decided in 1973, it essentially invalidated the abortion laws of the entire country, except the state of New York, more or less. So it was a very drastic restriction on the democratic process. So to that extent, perhaps something that the progressive pessimists of the 1930s would have taken issue with. Dobbs, at least as it's presented, at least at first glance, is an opinion that takes a step back on the grounds that the court had made an improper step into this area of significant social consequence and debate. That's obviously not the whole story when it comes to the critiques of the Dobbs opinion or the defenses of Roe v. Wade. Showed you this headline from before. The idea that the Dobbs decision was lawless, or the idea that the Dobbs decision to overturn Roe v. Wade was, as Justice Sonia Sotomayor put it in the oral argument, surrounded by the stench of politics. Something I would encourage people to go and listen to. You can easily go and do it at oea.org. All oral arguments of the Supreme Court going back to 1956. Justice Sotomayor asked the lawyers in the case, how can we avoid the stench of politics here? Because we've had this precedent for 50 years. We've upheld it in the intervening period. And now it seems that we are throwing it in the trash simply because the conservatives took over the court. That's lawlessness. That's pure politics. That's pure partisanship. Okay, and this is essential to the critiques of the Dobbs decision. Obviously from Justice Sotomayor, who was one of the three dissenters in the case, but also from commentators and scholars beyond. It must be said, however, that Justice Alito was clever in the citations that he chose for the opinion in the Dobbs case, because he chose many from liberal and progressive scholars who had been very critical of the existing precedent of Roe v. Wade. Chief among them, Ruth Bader Ginsburg, one of the biggest advocates of abortion rights and of women's rights in the United States of America, repeatedly criticized Roe v. Wade for being essentially an act of judicial overreach, unprecedented in its scope and reach, she said. The country was moving, albeit slowly, albeit incrementally, as it tends to do, in the direction of expanding abortion rights. And then the Supreme Court came in, put its thumbs very firmly on the scale, and disrupted that process, distorted that process. Maybe to such a degree that going forward, advocates of abortion rights thought they had won and did not put enough energy into legislation that would have been necessary to actually provide resources to make sure that the right was a reality. John Hart Ely, another liberal legal scholar of the time, put it rather more starkly in his analysis of the opinion itself. He said that Roe v. Wade was not constitutional law and gave almost no sense of an obligation to try to be. That is to say, and I think that there is some truth to this when one reads the Roe v. Wade opinion, it is a very interesting and compelling discussion of the different trade-offs and issues and stakes involved with a question of this magnitude. But the degree of constitutional analysis is rather thin at best. Then, the Supreme Court, in the Dobbs decision overturning Roe, did adopt a framework, a legal reasoning that was based on prior decisions of the Supreme Court. And it's pretty straightforward. It says, if we are going to protect an unenumerated constitutional right, that is to say, a right that's not actually written in the text of the Constitution, but we somehow infer from the spirit of the Constitution, then we have to find something that is deeply rooted in the nation's history and traditions. We cannot just have a Supreme Court justice or 5 Supreme Court justices waking up one morning and deciding this would be a good idea, let's make it a constitutional right. Okay? And in the Dobbs decision, Alito is referring particularly to a case from 1998 called Washington v. Glucksberg, in which this kind of concept was developed by the court. Although there was a little bit of disagreement about that I'd be happy to talk about later in the Q&A if people want to bring it up. So I think here we have at least a partial refutation of the criticism of Dobbs. And this is important for the wider point about whether the court is irredeemably politicized. It's simply politics by other means. I think we can at least make the case here that there is a defensible legal reasoning behind what the Supreme Court is doing. It's not simply making things up on the fly. It is not simply imposing, without any effort to justify it, conservative ideology on the country. We might say to this extent that at least the opinion is debatable. So all of these statements by constitutional law scholars saying, I can't even bring myself to teach the material anymore because the Supreme Court is so polarized, I think may be undermined by at least some effort to engage with the said material. Now, there's another argument here that's important because it's related to the power of the Supreme Court. I think this is vital. And this is, I think, actually what ended up being the leading argument made by defenders of Roe v. Wade in the Dobbs case. This is the idea that maybe there were some flaws in the original opinion from 1973. Maybe there was some limitations in the extent of the constitutional analysis or what have you. But the reality is, this is the precedent that we are living under in the United States today. And if we overturn it, even if it was wrongly decided, if we overturn it, there could be catastrophic consequences. And I don't think it's very difficult for us to understand what those catastrophic consequences might look like, because I think to some extent we're already witnessing them in the aftermath of Roe v. Wade being overturned. Obviously, wealthy women in states that have very strict abortion laws will still be able to get abortions. They'll just come to California or New York. But poor women, in particular, are the ones who are going to suffer the most from this lack of access. And this is something that Justice Sandra Day O'Connor pointed out way back in the Planned Parenthood v. Casey decision from 1992, that we're going to, as she put it, add inequity to the cost of repudiation if we overturn Roe. I sympathize with these arguments, but I also think that these arguments are very symptomatic of our exaggerated views of the Supreme Court's power. Why, I wonder, is not an ounce of the criticism that's directed towards the Supreme Court directed towards, for example, the United States Congress? After all, only the United States Congress could have provided the financial support that was necessary for women to actually be able to exercise this right in the first place. Congress did the total opposite in 1976, prohibited federal Medicaid funding to be used for abortions in the Hyde Amendment. And the general tone of political discourse up until the overturning of Roe v. Wade, particularly from the Democratic Party, which of course is the party that stands as being the party of abortion rights, was not, we're going to repeal the Hyde Amendment, although Hillary Clinton's platform in 2016 did actually say that. But beyond that, there's never been any concerted effort since 1976 for Democrats in Congress or Democratic presidential candidates to try and repeal the Hyde Amendment or try to do anything actually in federal law that would make the promise of Roe v. Wade a reality, even while they are well aware of the fact that conservatives are plotting and campaigning to eventually take over the Supreme Court and overturn Roe v. Wade. No effort from members of Congress to deal with this at all. Instead, they have a very good get-out-of-jail-free card or pass-the-buck card or pass-on the accountability card, which is, we will defend Roe v. Wade. The Republicans are coming for Roe v. Wade. We will protect the Supreme Court. This is a totally distorted view of the issue because Congress, or at least the elected branches, are the only ones that can provide the resources to make sure that the right can actually be exercised. And by the way, this is something that came up in the Dobbs oral argument and opinions in our peer democracies, a term I don't particularly like, but it's basically rich, relatively democratic countries like the United States of America. Abortion rights are much more strongly protected than they are in the United States, at least at the federal level, but not by judicial action, by legislative action, or even by constitutional action. Abortion Act of 1967 in the United Kingdom, for example. Okay? Actually, the High Court in West Germany did rule, I think it was in 1976, that there was a plausible constitutional right to abortion, but did not invalidate any existing laws by doing so, but rather recommended that the legislature take up the issue in order to solve it. Long story short is, the overturning of Roe v. Wade would not have had very much impact at all if our elected institutions were doing their job. And I think that as a result of this, we have ended up with a distorted perception. All the blame is put on the Supreme Court for overturning a precedent that it says is wrongly decided, rather than on other institutions that never fulfilled their responsibility, going all the way back to 1973. I'll briefly comment on another criticism here that I think is important. This is definitely related to the point about the court's ideological stance and the idea that, like I said, it's a conservative wrecking ball. In the dissent, and also in many commentaries on the Dobbs case, there was an argument that there is now a big threat to other constitutional rights, because the Supreme Court said the right to abortion was not deeply rooted in our nation's history and traditions before 1973. Therefore, Roe v. Wade was wrongly decided, should be overturned. Well, naturally, critics are saying, hang on a second, right to desegregated education wasn't deeply rooted in the nation's history and traditions in 1954. Right to contraception wasn't deeply rooted in the nation's history and traditions in 1965, before Griswold v. Connecticut. Right to interracial marriage wasn't deeply rooted in the nation's history and traditions before the Loving v. Virginia decision in 1967. Gay marriage certainly wasn't deeply rooted in the nation's history and traditions prior to the Obergefell v. Hodges case in 2015. You can see the logic. If the Supreme Court is now adopting this reasoning for so-called unenumerated constitutional rights, then we're going to see many other rights overturned. This is a big part of the criticism of Dobbs and of the Supreme Court more broadly. Now, I think there are lots of problems with this argument, but I'm just going to give you the one that I think is most noteworthy and, for me, the clincher. And that is simply that there are no cases pending or possible or efforts by anyone in the conservative legal movement to try and overturn any of those other cases. You can go test the theory for yourself. One of the leading organizations in the conservative legal movement, been involved in a lot of litigation, especially over the last few years, is the Pacific Legal Foundation. It's based right here in Sacramento. You can go to them and you can say, I've read the Dobbs decision. I think we need to overturn more unenumerated constitutional rights. Can we get a test case going that is going to say interracial marriage is no longer a constitutional right? Can we get a case going that's going to say that contraception is no longer a constitutional right? They're not going to respond. They're not interested in those kinds of cases. These issues are settled. There's absolutely no effort whatsoever from anybody in the conservative legal movement to go after these other cases. They're focused on other issues now. Yes, they are focused on some other culture war issues that I've already alluded to, like affirmative action and gun control. Again, I could talk more about those perhaps in the Q&A. But the larger focus, maybe the primary focus, is actually on particularly these ideas of property rights and also concerns about the power of federal government agencies exercising too much power. These are some cases that conservative legal scholars and the conservative legal movement broadly defined are focusing on right now. Not coming after every single unenumerated right that the Supreme Court has defined in the past. Now, I should say, it's important to say, since I've committed these views to print in various cases, I think that these other cases related to the powers of the federal government, the regulatory powers of Environmental Protection Agency, Department of Education, Consumer Financial Protection Bureau, I think that these are potentially dangerous. I think that these could invalidate very necessary federal regulations. And for the record, I think that some of the theories and doctrines on which they are based have a rather tenuous connection to the Constitution. I don't want to get into all the details because it's quite technical. Again, it's something that maybe can be saved for the Q&A. But I don't want to be complacent about this issue, and I don't want to be complacent about the Supreme Court in general. But what I would say, stepping back at the slightly more general level, is, number one, none of these cases about the powers of federal government agencies actually involve the Supreme Court engaging in a full frontal assault on legislation passed by Congress. Now, that could be because there's not a great deal of significant social legislation that has been passed by Congress recently. For example, suppose Congress passed legislation providing for universal health care, Medicare for all, a fairly popular policy. It's possible that that would be challenged at the Supreme Court. We would see a case. But generally, I think for now, some of these cases to do with the powers of federal government agencies are cases that we should just be monitoring rather than necessarily getting ourselves into a panic about. And at the broader level, I think a reason for that is that the Supreme Court, within our constitutional structure, is the weakest branch out of the three. There's no question about that. It does not have the power to enforce its own decisions. It does not have the power to provide any funding to support its decisions. As Alexander Hamilton put it in the Federalist Papers, it doesn't have the sword, it doesn't have the purse, it only has judgment. It's significantly constrained by the powers of the other branches. Most of our problems today can be addressed through, in particular, action by the United States Congress, and then if the Supreme Court challenges it, that's more like a constitutional crisis. But generally speaking, the court backs away from these kinds of confrontations. recognizing the limits of its own power. This actually goes right back to its earliest decisions as well. But this is what happened in the 1930s when the court got into a prolonged confrontation with progressives in Congress and in the White House. The court ended up losing that fight. And even I would say we can see a little bit of evidence in cases from the most recent term of the Supreme Court. The advances that it made on the front of the culture war, particularly on gun control and abortion, it took a couple of steps back in actually near unanimous decisions. So I think that the court is aware of its own weakness as well when it comes to the broader constitutional system. Let me conclude now by just telling you two things that I think we miss analytically when we see the Supreme Court, as I put it, as a conservative wrecking ball. Number one, I think we miss interesting discussions across a wide range of very consequential issues where the court is not predictably falling down the ideological lines of so-called conservative and so-called liberal. We have Justice Thomas, about as far right as you can get on the court, and Justice Sotomayor is about as far left as you can get on the court, in agreement about the court's need to revisit its cases about qualified immunity for police officers. Very important question that people were protesting about with quite some energy, particularly back in 2020. We have agreement between liberals and conservatives. We had agreement in the past between Justice Ginsburg and Justice Scalia about how we might deal with the question of our privacy rights, our Fourth Amendment rights in the digital age. We have absolute consensus on the Supreme Court, unanimous consensus on the Supreme Court about the fact that when the government wants to restrict freedom of speech, it can only do so on the basis of objective time, place, and manner considerations rather than because it does not like the message that's being expressed. This is unanimously held by the Supreme Court of the United States. Not to mention the fact that last election season, and I should be careful what I'm saying here given we have an election coming up next week, the federal judicial system in general laughed out of court all of the ludicrous attempts that the Trump legal team made to question the integrity and the legitimacy of the election results. So I think that we miss a lot of these things when we see the court or the judicial system as a conservative wrecking ball. And then finally, a very important thing that we miss, particularly when we think of the court as being divided down an ideological line, we miss one very important and perhaps concerning way in which the court is not divided at all. And that's in terms of the career background, the social background of all of the Supreme Court justices. Some of you might be thinking, this is a bit strange, because I thought that we have the most diverse Supreme Court in our history today. Yes, by gender and race we do. These are important things. But by career background, we have about as a monotonous court as you can possibly imagine. Every single one of them went to Harvard or Yale Law School, with the sole exception of Justice Barrett, who went to Notre Dame, which I don't think is very many levels down, if you want to use that particular expression. Pretty much all of them are professional judges. Their entire career has been go to law school, get a clerkship on one of the appeals courts, get a clerkship on the Supreme Court, become a judge on probably the D.C. Circuit Court of Appeals, and then end up on the Supreme Court of the United States. Very little experience with private litigation. Very little experience, let's say, generally, of the real world. I mean, Yale and Harvard, for example, on their own, are not exactly known as places where people were 100% in touch with the problems that we face on a daily basis in other parts of the country. Okay? Court's very unified in this respect. Now, I think there are definitely defenses of this so-called credentialed court. Might be better than having political hacks on the Supreme Court or something like that. This guy donated to my campaign, so I'll put him on the Supreme Court. Go ask Harry Truman. That's how half of his appointees got on there. That might not be a good thing. Nevertheless, we can, I think, identify potential problems here. Justices not being aware of how their decisions are going to have an impact on people in litigation, how their decisions are going to have an impact on the country at large, or how their decisions are going to have an impact on people in government, because it's certainly a feature of Supreme Court justices of previous generations that they also had a good amount of experience in government as well. So I think that this issue, this question, this problem, this concern of the credentialed court is something that we don't see at all if we see the court through a purely ideological lens. So, just say very, very briefly, in conclusion, you want the basic takeaway. Pessimism about the judiciary, good thing, democratic thing. Keep it up. When I first started seeing these opinion polls, I wrote a little piece for the American Constitution Society. And I said, why Americans are losing faith in the Supreme Court and why that's a good thing. Okay, you might think that's in direct contradiction with what I've just said over the past 40 minutes. But because of everything I described about the roots of pessimism in progressive thought, I think this is something that we should definitely keep in mind. But at the same time, while I think it's undeniable that we're looking now at a conservative judiciary and a conservative court, it's important not to get, I think, into this mindset of those constitutional law professors in that New York Times piece who came to the conclusion we simply cannot bear this anymore. We cannot even bring ourselves to study this anymore because the institution's so corrupt, it's so divided, it's so polarized, and it's so ideologically driven. I think if we have that mindset, we miss a lot of very important things about the Supreme Court. Maybe more importantly, we also let other institutions, particularly the United States Congress and particularly our elected political leaders, off the hook for all of their failures over the past decades. Thank you very much.
Thank you, Professor Blain. We will now hear from our formal respondents before turning to you, our audience, for your questions. Our first respondent is my fellow CRC honor student, Zuleika Amizada.
Thank you, Dr. Blain. I appreciate your talk. There are many great points that you brought up, and it encourages us to look more into this topic. I agree, informed pessimism definitely fosters change, tying back to the hope and change, more so than an ignorant form of pessimism. So it can definitely be beneficial for sure. My question is the issue with how the court interprets the Constitution or the power that their interpretation has? Is it a philosophical issue between originalism versus, let's say, living constitutionalism, or is it the power that their interpretation holds given that it is an unelected institution?
Thank you for the question. Yeah, interpretation versus power. Well, something I didn't talk about was this question of the methods or the modalities of interpretation, right? And particularly, I'm glad you bring it up, particularly the rise, maybe the dominance of this originalist mode of interpretation. And I think there's a lot of good debate to be had about that. I fear that the more blind pessimism about the Supreme Court simply assumes that originalism is a trick by the conservative justices to sort of smuggle in their own political views and give them a veneer of legitimacy. I also think that a lot of critics of the court and critics of originalism don't really understand it. I think some of my students here will know we talk about what it's really all about. It's not about freezing things in time at the time that the Constitution was written necessarily, but it is about making judgments today based on generally what the original public meaning of the document is and was. And liberal and conservative justices, liberal and conservative legal scholars all do originalism to some degree. Best example, probably best originalist opinion ever written, at least in recent times, unanimous, by the way, Timms v. Indiana from 2018, which is a slightly obscure issue. It's about incorporating the excessive bail clause of the Eighth Amendment against the states, written by Justice Ginsburg. And it's full-blown originalism about the original meaning of the 14th Amendment in particular. So I think these questions of interpretation are important. And, I would throw them into the mix of all of this. This is something that I think should be debated and should be discussed and shouldn't be assumed to be illegitimate. In terms of the power of the court, well, I think you got my view more or less, which is I think that the court's actually pretty weak, but we have an inflated view of its power. And I would put it maybe a little more specifically now, because I should have said this in the talk, the power of the Supreme Court, let's say, it's only as powerful as the other branches, especially the Congress, are impotent, thereby empowering the court through their own inaction. But I think that the problem right now is, inflated idea of the power and maybe a slightly blinkered idea of the interpretation, assuming that the interpretation is illegitimate without properly assessing it.
Our final respondent is my other fellow CRC honor student, Raj Bahar.
Thank you. Thank you for your talk. I'm one of those young pessimists that your talk and I suppose this entire symposium is targeted towards. And I think you've given me a lot to think about the Supreme Court. And I do think that some of the pessimism that the Supreme Court is facing is rather undue. You know, I read the article that you mentioned by Jesse Wegman. It seemed rather politically charged, to say the least. And I don't believe that he would have the same issue with, say, the Warren Court making politically activist decisions. And so I largely agree with you that there is a bit too much pessimism about the Supreme Court. But you asked me to be critical of you, and so I will be more than happy to be critical. So you say that criticism should be levied to Congress, and that, you know, in large part, Congress's inability to legislate and to make amendments to the Constitution is why the Supreme Court has taken up the sort of the mantle of needing to legislate and needing to create this change in society. You know, Brown v. Board, they're the ones who end segregation. And we see that the Supreme Court has largely, while they're an unelected office, they have largely taken the role of Congress in a lot of regards. And, you know, just because Congress is unable to do these things, that doesn't mean that the courts should. And it certainly doesn't mean that the courts should step in and make these far-reaching, legislations. And while you can say that, you know, the court is the weakest branch constitutionally in the articles of the Constitution, that argument doesn't hold up when you consider their practical powers today. In large part, the office of the presidency and the office of the Supreme Court, or the judiciary rather, have grown much more powerful than they were originally intended to be in the Constitution. And we know that this power, especially the power of the judiciary, is rather expensive. They are the ones who ended segregation. They are the ones who created abortion protections during Roe v. Wade. And, I think that the idea that just because Congress isn't doing its job, the courts should be able to do it for them is, it's treating the courts as if they're, a benevolent monarch. You mentioned that the courts aren't looking right now at interracial marriage laws or, they're not looking at gay marriage laws. Isn't the fact that they have the ability to look at those concerning? Isn't the fact that, they have the ability to make legislation on these concerning at all?
Thanks. Yeah, well, I agree with actually a lot of what you're saying, especially to the last question. Yes, I think in terms of the Supreme Court in many areas of our life having authority over fundamentally political questions, I think that's a symptom of a sick system, which I think anyone can look around to a large degree and see that the system is somewhat sick. And I think that is partly the federal government in particular, the Congress in particular, seems to be very incapable of dealing with a lot of our major problems. And I think, partly because of that, the courts become more powerful. So I agree with you on that point. I want to highlight the point you made about the court being more powerful in reality than it is on paper in the Constitution, because I agree with that 100%. I think that's a good point. The courts become more powerful over time, I think, for a lot of reasons. I still think its power, though, does rest in the extent to which everybody else respects its judgments. It hasn't actually developed any new enforcement power over time of note or financial power to actually implement its decisions. So I think that the original insight of Hamilton still actually holds, more or less, but I think that one way or another, the other branches, even us as a society, have actually reconciled ourselves with the notion that the Supreme Court's sort of the final arbiter, at least, on constitutional issues, judicial supremacy, let's say. And I'm not sure how I feel about that, but I think I agree with that. Finally, I would just say with respect to the court ending segregation, I'm not sure I would say that. I think it did have a big impact with respect to Roe, but I don't think it ended segregation. If you look at the actual process of desegregation in the United States, it really only started with the Civil Rights Act of 1964. But I think you could argue that the process of getting to the Civil Rights Act, the momentum of the civil rights movement was definitely boosted by Brown v. Board of Education.
I have another question for you. So are there not structural problems with the current nature of the court? To name some, the lowering of the threshold for appointment that Republicans passed. You used to need to have 60 votes in the Senate. Now you only need a simple majority. The idea of lifelong appointments and the idea that a single president can, Donald Trump appointed 3 Supreme Court justices. And, if we look at, the Supreme Court as a pendulum, right, sometimes it'll be liberal, sometimes it'll be more conservative. Having it be able to be so far in one direction at one time and having the pendulum swing so far, is that not a structural problem? And is this not signatory of the fact that there needs to be significant reforms to the court?
Yeah, I think definitely the life tenure point in particular. This country needs to get up to date with the rest of the world and put term limits on Supreme Court justices, long-term limits, 22 years or something, so they're staggered with election cycles. Yeah, I mean, it's ridiculous, waiting around for people to die or celebrating when someone dies or trying to make someone resign. Or it's not right. You could just see it. It doesn't work very well, and I think the Trump administration and the shenanigans of the Republicans around Merrick Garland as well is all evidence of the mess there. Maybe one day we will get that. Obviously, we need a constitutional amendment for that. It's really hard to get constitutional amendments passed. But I think maybe one day that could happen, that we actually get up to date with the rest of the world. But we might be like 100 years behind or something like that. I think that would be a very good reform. The filibuster point about the Senate, yeah, I really hate the filibuster, I guess is my feeling, whether it's for judicial nominees, cabinet nominees, or legislation. I think the supermajority requirement in the Senate is part of what's led to the basically dysfunction of the federal government. So I would really like to just do away with it across the board. But I mean, that being said, I do have some sympathy for it actually with judicial nominations, precisely because you're right. I think that the judicial nomination process has become a joke. And it's become a circus. I mean, every time it's this big... no one's even interested in asking questions in the Senate. They're just interested in getting on their soapbox and making some kind of canned speech. And that's very unfortunate. And it's probably become worse without the filibuster. But I wonder if it's getting rid of the filibuster, or it's just that maybe judges and the whole process has become more ideological over time. I mean, again, I was kind of pushing back against the idea of it being super ideological or predictably ideological, but there's no doubt it's become more ideological. And, I again invite people, if they want to do something later, go look at on YouTube some of the old nomination hearings, for example. Look at Scalia's. That's a pretty funny one. That's from the 80s. Scalia's smoking a pipe throughout it, which I think also tells you how times have changed. But the nomination hearings were very different back then. Go look at Ginsburg's even. I mean, they're all confirmed with... You don't need the filibuster. They're confirmed almost unanimously. So I think there's kind of a problem in the culture around the judiciary that might be more to blame than getting rid of the filibuster.
Thank you, Raj. And thank you, Professor Blain. In a moment, we will turn to you, our audience, for questions. Dr. Swan will moderate this portion of the session. But before I turn the floor to Dr. Swan, I would like to utilize my prerogative as session chair and offer a question myself. Professor Blain, so in your discussion, you mentioned while pessimism is healthy, where do you think the boundary lies in pessimism in discussion of the Supreme Court?
That's a good question. I mean, I don't really have a good answer to that, other than to sort of reiterate what I was trying to say, which is, in general, the starting position should be pessimism, but it's not good to do things backwards, assume that the court is politicized or improper or something like that, and then base our perceptions of the court on that starting assumption, but approach the court how we basically approach anything, which is, let's read the content that comes out of it, let's look at the content that comes out of it, and try to deal with that content, analyze that content in the most dispassionate, intelligent way that we can, and then draw conclusions about the degree to which we should be pessimistic.
Okay. Hello, Professor. Thanks to the excellent examples on the presentation, I conjured up this question. So, in your opinion, does the court protect or hinders the progress in social justice movements?
Protect or hinder, was that it?
Does the court protects or hinders the progress in social justice movements?
I think historically speaking, it sort of usually hinders. And in a way, I think that's kind of the court's role. I mean, the piece that I wrote for the American Constitution Society, that's kind of a progressive organization. And when I said it's kind of good that people are losing faith in the court, I said basically the years of the Warren Court, which Raj mentioned from 1953 to 1969, led a lot of progressives to believe that the Supreme Court can be a major agent for social change, even at the vanguard of social change in terms of expanding people's rights and liberties. But I think that that's just kind of wrong. I think that the court in that time was at best a sort of junior partner in the process of social change developing. But generally, I think it's an inherently conservative institution. I mean, the whole basis on which every Supreme Court opinion starts is backward looking. Even if you don't believe in originalism, you believe in precedent. So what did we say 50 years ago? And how is that relevant? So it's an inherently backward looking institution. And I struggle to see how an inherently backward looking institution would be an agent of social change.
Hi, Dr. Blain. Thank you so much for the talk. I found it very interesting and provocative, and I also want to thank the students from CRC for the wonderful questions. So you made reference to this, so this will give you a chance to say a little bit more about this. What would you say to those who disagree with the standard, the test, that something is deeply rooted in the nation's history and tradition that was established in the Washington versus Glucksberg case in 1997 and then applied retrospectively to the 1973 Roe versus Wade case? And then sort of restating the last student's question, or actually maybe the second student's question, having established this standard, even if there is no current movement to overturn these unenumerated rights, don't you think these rights are still in jeopardy because of this established standard?
Thanks. So the first point about let's say the Glucksberg test, the deeply rooted traditions, I've gone different ways about it in terms of thinking about it as a legitimate test. I suppose that the one thing I can say in its defense is that I'm failing to see what a better alternative is. It seems to me that the better alternative that I usually hear is something along the lines of living constitutionalism. And for me, that's just too vague. That's just a license for a Supreme Court justice to decide that something's an unenumerated constitutional right off the seat of their pants, as we say. And I would not like to see that happen, basically for the reasons I was alluding to at the beginning of the presentation. Who's to say that this won't then empower the court, it's a conservative one, after all, to start to revive some of these ideas from the early 1930s about liberty of contract, maybe about other economic rights and liberties that would actually constrain the ability of, I suppose I'm outing myself as someone sort of on the left, constrain our ability to pass progressive legislation. So I would defend the deeply rooted tradition test because I think it's a good guardrail against judicial activism. That would be my defense of it, I suppose. In terms of the other rights being in jeopardy, my general answer would be no. I mean, for one thing, the Obergefell, a couple examples. Obergefell marriage equality is now basically protected by Congress, by federal law. So I think that that's pretty much safe. And I think that with a lot of the others, the situation was really different in those cases than in Roe v. Wade. Like I said, Roe v. Wade overturned basically all the abortion laws of the country. Griswold v. Connecticut about contraception was essentially the opposite. I mean, Connecticut had this absolutely antiquated law that married couples couldn't use contraception. And it was the only state in the country that had a law that was quite so extreme and antiquated as that. So I think that it could have been argued, and it sort of was argued at the time, that it is, in fact, increasingly rooted in our traditions at this point. It's increasingly widespread that contraception is none of the government's business. This is something that's up to consenting adults. And I would say the same about a lot of those cases from the past, including Brown v. Board of Education. I mean, I think Brown v. Board of Education was a case that really carefully grappled with the question of how the 14th Amendment should be applied. It was based on a lot of precedents addressing the question of so-called separate but equal education in different areas over the previous few years. None of these decisions were anywhere near as radical as Roe v. Wade. I think that Roe v. Wade really was quite a radical decision in terms of what it did. Separate question, like I said, about whether it should be overturned. I mean, I think that my instinct is I would probably say it shouldn't have been overturned because of the impact of overturning it, and also because of the fact that one way or another it maybe did actually get us to a decent compromise position nationwide. But I think it's in a totally different category to all of the other cases. So apart from the fact that no one's trying to bring the cases, which I think is the most important point, and I don't think anyone will, and this is being recorded, so you can use this evidence against me later on if you want. I think that all those other rights are safe.
Going to the area that you do think is in trouble now against the overturning of Chevron with Relentless and DOC, I'm going to try and make a case why they should have, using your logic. You said that the main logic here is if we allow the Supreme Court, if we're disparaging the Supreme Court for this, we're letting those who are supposed to be on the hook off the hook. From what I understand from the interpretations of Chevron and the other things, they are pulling back the essentially standard position that agencies have the correct interpretation of the law. And isn't that, from your opinion or from your position, saying that they're actually upholding it and they're actually saying, Congress, you should be actually enumerating what these laws mean, and you shouldn't make the executive have to decide what your laws mean, and that the Congress should be the one saying what the laws are, and not the executive branch?
Yeah, that's a great question. It's very good because it exposes a bit of a contradiction in what I was saying, which is exactly why I wanted people to make the challenge. And you explained, I think, Chevron well. I was going to say we need to explain it because people probably don't understand what we're talking about to a large degree. Okay, but this is one of these recent decisions that the court has made, which is going to get the courts much more involved in questioning the actions of federal agencies who are acting on broad delegations of power from Congress. And so from a sort of outcomes perspective, the argument here that we see a lot is it can endanger environmental regulations, financial regulations, and so on and so forth, right? My position on Chevron is actually pretty close to yours, at least as you articulated. I don't know if it's actually your position, but it's pretty close to that, actually. I think that the overturning of Chevron, I think, is pretty justifiable. And I think that Chevron itself, not the best opinion ever written by the Supreme Court either, even though it was unanimous. I'm more concerned, and yell at me if you think I'm dodging the question, but I'm more concerned about some of the other cases and theories invalidating actions by the federal government. And in particular, I'm concerned about this idea of the major questions doctrine, okay? This is nonsense in my view. The major questions doctrine is something that the Supreme Court invoked most recently in a case that I suppose people would have followed but maybe not thought about it from this point of view. Biden administration's efforts to cancel student debt. And people probably following that, you're like, damn Supreme Court overruling the Biden administration. It did so on the grounds that legislation from 2003 granted the Department of Education pretty broad powers to modify or adjust student loan repayments. And acting on that very broad authority, the Biden administration implemented this plan of relieving quite a substantial amount of student debt nationwide. The argument from the conservatives on the Supreme Court, it was a 6-3 decision, was that Congress could not have possibly wanted to do this. Congress, quoting a decision from before, doesn't hide elephants in mouse holes. If it wanted to authorize the executive branch to forgive student loan debt on such a big scale, then it would have said so explicitly. This is the major questions doctrine. I have a big problem with this because I think that this so-called major questions doctrine maybe is supported by a degree of common sense. It is also supported by this idea that Congress ought to do its job, for sure, shouldn't just palm things off to the executive branch. But I struggle to see how that's based in the history, text, tradition, any of these important things to do with grounding the decision in the Constitution. So I'm more worried about that stuff, I would say, than Chevron. And I'd also just say more generally, I'm less concerned about Congress delegating power to the executive branch. I mean, I think Congress does this. Congress does this a lot. Now, I actually think it could be a problem for the democratic process that we should correct, but I don't really trust the Supreme Court to get in the business of policing the boundaries between appropriate delegation and inappropriate delegation. Again, for the reasons I stated at the beginning about, let's say, the progressive pessimist view. So there's kind of a practical point there, but there's also concern about the court invalidating some of these agency actions on what, in my view, kind of dubious constitutional theory. So you can read my article, the very clickbait title that I didn't write, but you can go and read it, Why the Major Questions Doctrine is a Threat to Democracy. I think, whoa, okay, that's a little much. But that's in Jacobin magazine. You can go and read that. You'll see more of the argument there.
So just a follow-up question. You touched on this a little bit, and also from everybody else's questions, but do you think the actions of the Supreme Court is rational or somewhat powerful in shaping America's society?
Yeah, I guess is the short answer. Yeah, somewhat powerful, maybe a little bit too powerful because of the inaction of our other institutions. Do I think it's rational? I suppose. Yeah, I mean, I think that we can always they have to provide at least some defensible, rational explanation for what they're doing. So I would say it's rational too.
Yeah, I have a question about the value of transparency in being hopeful about the Supreme Court, because transparency has sometimes been thought of as a almost like all-purpose tonic that helps institutions do better. However, in the Dobbs deliberation, you may recall there was a famous leak of the case, which led to, among other things, a Californian going to try to assassinate a Supreme Court justice. So do you think that transparency perhaps is not a good thing for, the Supreme Court? Should they continue to have their deliberations in the traditional secrecy that they've been had? And if so, does transparency come in at a different part of the process, like the nomination process or something?
Yeah, I mean, I agree with you about general skepticism about transparency. I feel like it's the kind of thing sometimes you go to the town hall and you ask for the government to do something substantive, and instead of doing it, they offer transparency. So I'm not always a fan of transparency. I was struck by something that I heard from the former chief judge in California, actually, who was here at an event last year. I'm now failing to remember what it was even about. But anyway, I was just talking with her, and she made the point that for all of its faults, and she had lots of criticisms of the Supreme Court in particular, for all its faults, it's a pretty transparent institution, very transparent institution. Okay, we don't get into all of the deliberations, but we can read all of the briefs that are submitted to the court. We can listen live to the oral arguments of the court. Bit of discussion about whether there should be cameras in there. Forget about it. It's fine. Draw the pictures, listen to the oral argument. We get the transcripts. We read the opinion of the court. We read the dissents. We read the concurrences. I think the Supreme Court's a pretty transparent institution, actually. And I think that that's to its credit. And I think that really the problem for me is not lack of transparency. I think it's bad coverage of the court. And I think that journalistic coverage of the Supreme Court in particular is sort of generally awful because it's all based on this lens of partisan polarization. Everybody's going in looking for the most partisan or polarizing cases and then reporting on that basis. So I don't think it really needs more transparency. I think it's already pretty transparent.
I wanted to challenge, if I make sure if I got your position correctly, both that the Supreme Court does not in fact actually have that much power, and that's probably a good thing. I want to push back on the good thing part of it. I mean, the Supreme Court is the only explicitly anti-democratic branch of our government. We have two that are explicitly democratic and one that's explicitly anti-democratic. And so in that sense, I think the first part is right. They can be outweighed clearly by the democratic branches. But would you be sensitive at all to the argument that we need an anti-democratic branch, or we need some anti-democratic forces in order to push back against standard tyranny of the majority situations? I mean, it's not hard to find clear examples in the history of the Supreme Court where they argued for what was morally the right position, even if it wasn't democratically particularly popular. And presumably that's going to continue on into the future. So wouldn't a strengthened court that has the power, again, obviously assuming they can get the moral questions right, be a good thing to check against popular democratic prejudices?
Big assumption in there at the end, though. Assuming that they get the moral questions right is a bit of a big one to have in there. I mean, I'll give you the direct answer, or I think the succinct answer, which is, for me, yes, the court does have an important and useful role, but I think that its role in checking the democratic institutions should be rooted in either the text of the Constitution or in some identifiable, clear tradition that we have developed over time as a society. I think that that's basically it. Going beyond that, I think, is very dangerous. But should the Supreme Court protect freedom of speech despite what majorities say? Yes. Should it protect civil rights despite what majorities say? Yes. There, I think the court had to do a bit more work in reading between the lines of the Constitution, but I think Brown v. Board of Education, for example, is one of the most carefully reasoned opinions in the history of the Supreme Court, and actually one of the most careful historical analyses in the history of the Supreme Court, in my view, which is not always what people think about Brown v. Board, because there are parts of it that aren't like that. But I think that overall, it really is like that. So, yeah, that would be my answer. I think all good as long as the court sticks to something that is an identifiable constraint. Otherwise, we can have this issue of judges acting like our overarching moral overlords, which is something I'm very scared of, wouldn't like.
Roe v. Wade didn't sound perfect, but it did provide the protection of the right to abortion. I would like to hear your opinion, perspective on how we could restore that protection, that right, and what the role of the Supreme Court would be in that.
Yeah, and you heard me say before as well, I think probably despite all the criticisms, I would have thought the court should have upheld it for kind of practical reasons and for upholding its precedents, let's say. Well, now forget about the Supreme Court in terms of protecting abortion rights. The court's made that very clear. Bye-bye. We're done. There might be some extreme cases where it comes up again. I mean, I alluded to, there's this case, ridiculous case, let's be honest, from a bunch of concerned doctors who tried to have the FDA's approval for the mifepristone abortion pill ruled unconstitutional, and the Supreme Court laughed that down 9-0, and rightly so. There might be other cases like that come up, but in terms of the question of the right, forget about the courts. What do we have to do now? We have to do what all other developed countries have done. If we want to guarantee this right and make it a reality, then we have to do it through the political process. And that's what people are doing, actually. You can see it right now, watching our usually pretty low-standard, depressing, useless election campaign. You can at least see that this is part of the debate. It's part of the presidential debate. It's part of many debates at the state level. I mean, the first elections, midterm elections, after the Dobbs decision, abortion was on the ballot, and actually, pretty much across the board, efforts to further restrict abortion rights were voted down when voters actually got the chance to address them, for example, in state referenda, or expanded, for example, even put into the Constitution, like here in California and in other states as well. So that's it. I think we have to, and I think it's probably the case for lots of other rights or things that we believe are important rights in the society, that we have to, as a society, sort of grow up and no longer rely on our benevolent 9 monarchs to protect our rights, and instead actually fight for them through the political process.
I've got one question. I'll bring us back to 1973 with Roe being decided. Your argument is that it might be more small d democratic if this would have been left up to the political process. So my question is, what percentage of women held office at the state legislative level what percentage of people of color held office in the state legislative level, what percentage of not white men held office in Congress, and how can we call those political branches small d democratic in that context? And the second question is about the history and tradition argument. Since the Declaration of Independence, we have a long history of life, liberty, and the pursuit of happiness being fundamental principles. And we have a long history of protecting ownership over one's property. And so there's a long history of being able to control one's own property, and men can control their own bodies. There's a long history of men having many choices, but it seems like there's a long history of just women not having that. And so if we are true to our principles and our long history and tradition, the right to abortion seems to fit within that practice. So those are two questions.
Thank you, Professor Tuchka. Let me start with the second one about the long tradition of individual liberty, property, and bodily autonomy. Let's say, because this is actually the key concept that underrides the Roe v. Wade opinion in the first place. Other justifications have maybe come up since, but that's the original foundation on what it was built. I think there are some problems with extending the concept to abortion in 1973. First one being that it hadn't even been one step towards doing that in any prior precedent at that point. So from just the perspective of the court, I think that that's a bit of a problem. Other point is, while we've recognized rights to bodily autonomy, especially back then, but still today, we do actually restrict bodily autonomy for everybody in lots of different ways. I mean, everyone here probably had to provide proof of vaccination before they enrolled in college. That's an obvious infringement on your bodily autonomy. Today, states have laws banning prostitution, banning incest, banning certain use of drugs that they deem to be harmful. These are all infringements on people's bodily autonomy. So while there's a tradition of expanding bodily autonomy, there's also a tradition of restricting it. And I think that that tradition's pretty deep and pretty significant. And I think then there was a problem with Roe v. Wade in that Roe v. Wade sort of acknowledged, and Justice Alito, of course, quoted this, Roe v. Wade sort of acknowledged that abortion is a different issue from some of those other bodily autonomy issues because, this is Roe v. Wade I'm quoting now, it's not my words, the state has a legitimate interest in protecting unborn life. And once you bring in that concept of unborn life, you can't get away from it. And this, I think, makes abortion a different issue to all of the other issues. By Roe v. Wade's own admission, there is the question of unborn life. And so I think that's another thing that maybe distinguishes it, and I think legitimizes some of the criticisms. As for the democratic process at the time, yes, I'm very sympathetic to this argument. I would say that in terms of the proportion of women, people of color in state legislatures at the time, probably pretty similar to what it was on the Supreme Court, which was zero, right? Probably in that sort of ballpark. I think that this is obviously a legitimate criticism still today. I think if do it through the democratic process, well, a lot of these state legislatures are a bit of a joke. I mean, they sort of turn up when they feel like it. Some of them don't even get paid. And we expect them to be kind of these great representatives of democracy. I think that's a big issue, legitimate concern today, as much as it was back then. We can't sort of glorify or glamorize the so-called democratic process. I mean, after all, this is why Thurgood Marshall and the NAACP adopted a whole litigation strategy to try to get to Brown v. Board of Education that they worked on for basically 50 years. They did that because there's no hope of them getting in on the glorious democratic process in Alabama in 1945. I mean, impossible. So they went to the courts. But I think that the argument on the other side there, which I'm also sympathetic to, is just because the democratic process is either severely flawed or discriminatory or whatever, doesn't mean we can or should shortcut it by going through the courts necessarily. And then it sort of depends on what the process is like, because I think the process of Thurgood Marshall NAACP is a process that's very legitimate in terms of the role of the courts, because it's building up over time, it's identifying precedents, it's a very serious analysis of the history of the Equal Protection Clause. I mean, on the demand of Justice Frankfurter, they heard a whole other round of oral arguments and briefs in the case on the sole question of what the framers of the 14th Amendment thought about segregation of schools. So they did really serious historical analysis in the case. None of that stuff in Roe, sadly.
We have reached the end of our session. Please join me in thanking our speaker.